Hello friends, this is Sanjay. In this 5-part series, I will be covering an overview or a quick revision of interpretation of statutes and principles of legislation as per the Karnataka State Law University, that is the KSLU LLB syllabus. The syllabus is common for both the 3-year and 5-year LLB. In each part of this series, I will be covering one unit from the syllabus. While I have included all the topics and concepts as mentioned in the syllabus for each unit, the order or the sequence of the topics may be a little different for better explanation. Let us get started with video 1, that is unit 1, interpretation of statutes. Let us start with a small activity. Pause the video here for 1 minute and see if you can spot the difference between these two panels. So go ahead, pause the video and unpause after 1 minute. If you found the difference, congratulations. If not, let me explain. You can ignore all of the graphics. They are just a distraction. Focus on the text. As a legal professional, you'll be drafting or you'll be reviewing plenty of contracts and other legal documents. It is very important to pay attention to the language and the grammar of the documents, and also to understand what was the original intention behind the words used. In the first panel, the boy is saying, "Let's eat, grandma," which can be understood as the boy telling his grandma that they should eat something together, lunch or dinner or something. In the second panel, the comma is missing. So the sentence now reads, "Let's eat, grandma," which can be understood as the boy telling his brother that they should eat their grandma. So the absence or the presence of a comma can completely alter the meaning of a sentence. As we will discuss in the context of interpretation of statutes, when you are reading a legal document, you will first try to interpret it precisely as what the words mean. But if that interpretation is leading to an absurd or an illogical conclusion, like the boys wanting to eat their grandma, you should look beyond the simple words and try to understand why this sentence was used, what was the situation when it was used, and interpret it as per what would have been the real intent of the author. Before we look at interpretation of statutes, we should first understand some basic aspects about statutes, starting with what is a statute. Various jurists and legal scholars have defined a statute in different words. Maxwell considered a statute to be the will of the legislature. Crawford said that a statute is the written will of the legislature. And the Collins Dictionary defines a statute as an enactment of a legislative body expressed in a formal document. You can see that there is an overlap in these definitions, and the main points that we can extract from these are that a statute is an act by the legislature, either by the state or the central legislature. It should be in a written format so that there is no ambiguity and everything is expressed in black and white. It should be a formal document. That is, it should have gone through the formal process of creating a statute. The makers of the statute should have the powers and it has been approved, etc. Though these two terms, statutes and laws, are often used interchangeably, they are not the same thing, because all statutes are laws, but all laws are not statutes. The term law has a wider scope. It includes statutes, which are the formal written laws created by the legislature. It also includes rules and regulations, which may be based on the powers or the rights given by the statutes. And it also includes case laws, which are the judicial interpretation of the statutes. Article 13A of the Constitution defines the term law as including any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. In this series, we are specifically discussing about the interpretation of statutes. So when I say law, it means a statute, unless I indicate otherwise. This is the life cycle of a statute. Understanding the overall life cycle and knowing the specific details of a statute are very important in the interpretation of statutes. We have previously discussed how an act goes from being a draft to a bill. It gets passed by the parliament and gets assent from the president or the governor and becomes a statute. Knowing the specifics of how a statute was drafted and passed will help in understanding the legislative intent. Knowing the specifics of the commencement of the statute will help us in understanding its application. Knowing about the operation of the statute will tell us about its extent and its scope. Understanding the repeal process will help in situations where there is a question of whether a statute is active or has been repealed. And understanding the revival process will help in situations where a statute has been revived either fully or partially, either expressly or through implication. When we discuss each of these steps in detail, you will get a better idea about their implication in the interpretation of statutes. Once an act is passed, when does it commence? Why is the commencement date important at all? Let us consider an example. Once upon a time, there were little or no restrictions on bringing gold into India. There was a businessman who had gone to some foreign country, and on the way back he purchased some gold to bring back to India. When he boarded the plane, it was the 9th of January. On the 10th of January, the government of India published a new law in the official gazette that put severe restrictions on the import of gold. When the businessman's plane landed in India, it was the 10th of January and the gold was seized by the customs at the airport. His argument was that he was not aware of the new law since it was published when he was flying. The counter argument will be that publishing the law in the official gazette is the official notification of its commencement, and ignorance of the law is not an excuse. So, the commencement of the law can be quite important in certain situations, especially when there is a question about whether the law was in force or not at the time of the action or the transaction that is supposed to be covered by the law. Article 20, subsection 1 of the Indian Constitution says that no person shall be convicted under any law that was not in force at the time when the act was committed. Because if the law itself was not in force, then the action of the accused could not have been an offence. If the statute came into effect after the actions of the accused, then conviction on the basis of the new law would be giving it a retrospective effect. While Article 20 subsection 1 prohibits conviction or penalty under retrospective criminal statutes, it does not say anything about civil statutes. However, the general principle is that laws should be prospective and not retrospective. Whenever a significant new statute is enacted, there would be some cases where this question of whether the statute was in force or not will arise. So, the commencement of any statute can be determined in three ways. The statute itself may mention the date from when it will come into force, like it does in the Income Tax Act. It may be mentioned in the official gazette when the statute is published. Or, if the Act itself and the gazette are silent about the commencement date, then it is considered to be in force from the day when it received the assent of the President or the Governor if it is a state legislation. These ground rules about the commencement of statutes are as per Section 5 of the General Clauses Act. Next comes the operation of a statute. Typically, central statutes will be in force throughout the territory of India unless specified otherwise. For example, before the abrogation of Article 370, many statutes would have the specification mentioned in them that they would not be applicable in the state of Jammu and Kashmir. If no such exceptions are mentioned, then central laws will be applicable across India and state laws will be applicable across the particular state. In some cases, the application of an Indian statute may be extended to beyond normal Indian territory. For example, if an offence under the IPC is committed by an Indian citizen, then the IPC will be applicable even if the person is outside the territory of India. Or the Indian Penal Code will be applicable on any person, even a non-citizen, who commits an offence on an Indian registered ship or an aircraft, even if the ship or aircraft is in international territory at that time. Or in case of a cybercrime, then the IPC will be applicable on any person irrespective of where he or she was at the time of committing the offence, if the target computer resource is located in India. There are also several acts which have state-specific amendments, like the CPC, where some sections are not applicable or apply in a different manner in some states. So, as we can see, understanding the operation of a statute is very important in the process of interpretation of statutes. When a statute ceases to be in force, it is considered to be repealed. The repeal of a statute happens in several ways. It can be an express repeal, where a new statute or a repealing statute are enacted, which specifically states that XYZ Act of such and such year is hereby repealed. Sometimes the repeal may be implied, such as when a new statute is enacted on the same subject as an older statute and there is an inconsistency in their operation. Then the new statute takes precedence and the older statute is implied to be repealed. For example, if an old law says that people cannot smoke inside a building, you can assume that people can smoke outside a building. And a new statute is enacted on the same subject which simply says that you cannot smoke in public areas. Then any place either inside a building or outside a building which can be considered to be a public place or a public area will become a no smoking zone. This leads to a possible inconsistency between the two statutes, because under the old statute a person could smoke outside and the new statute contradicts it. In such a situation, the old statute is considered to be repealed to the extent of the inconsistency. Repeal can be total, where a complete statute is repealed either through express repeal or implied repeal. Repeal may be partial, where only some parts of a statute are repealed either through express or implied repeal. Some statutes come with a built-in expiry date or a sunset clause, stating that this statute will be in force for a period of 10 years from the date of commencement or something like that. This is common in statutes connected with specific programs like special economic zones or tax benefits for industries in some parts of the country, where the program or the benefits are intended to be active for a specific time period only. What happens when a statute is repealed? Well, this can be understood better by looking at Section 6 of the General Clauses Act. First of all, if the legislature has some specific intentions as to what should happen after the act is repealed, the intentions should be specifically mentioned in the repealing act. For example, if any benefits, rights or liabilities created by an act are supposed to be extinguished, then the repealing act should provide the details. If the repealing act does not mention anything, or if the statute expired due to a sunset clause, and it is silent about the post-expiry situation, then Section 6 of the General Clauses Act will apply. This section says that unless there is a different intention specified in the repealing act, the repeal of a statute will not automatically revive anything. For example, if the Companies Act of 2013 is repealed without a replacement act, it will not automatically revive the previous Companies Act of 1956. The operation of the statute when it was active will also not change. That is, any rights, privileges, obligations or liabilities that were created when the act was in force will continue. Any penalties, forfeiture or punishments will also continue. Any investigations or legal proceedings that were started under the old act will also continue to their logical conclusion, as if the act has not been repealed at all. To summarize, when an act is repealed, if the old act or the repealing acts do not mention anything specific about the post-repeal situation, then the rights, benefits, liabilities, punishments under the old act will continue as usual. Only new rights, new benefits, new liabilities or new punishments cannot be created under the repealed act. The last step in the life cycle of a statute is a revival. Revival means getting a repealed or an expired statute back into effect. If an expired or a repealed statute is to be revived, then a specific act has to be passed by the legislature for its revival. It can be a simple act which specifies that such and such statute has been revived, or it can be a little elaborate, mentioning any changes to the revived statute, clarifying whether the old statute is revived fully or partially. This revival act will have to follow the same steps as any other act passed by the Parliament or the state legislature. Section 7 of the General Clauses Act deals with the revival of statutes, and it says the same thing, that if an act or a statute is to be revived, then a new act or a statute has to be passed to do so. This revival of acts is not being done frequently these days. The normal process is to pass a new act which includes the required provisions of the old act. For example, the Prevention of Terrorism Act, that is POTA, which was enacted in 2002, was repealed in 2004. Later on, some of the provisions of the POTA were revived through the Unlawful Activities Prevention Amendment Act in 2008, and it was added into the UAPA Act of 1967. Practically speaking, if the process of reviving an old act is taking the similar amount of time and effort as passing a new act, then it makes sense to just pass a new act itself, after including the provisions that you want to revive from the old act. As I will discuss in a little more detail, statutes can be classified on the basis of their duration, their nature of operation, or their objective. The first criteria for classification of statutes can be their duration. They can be perpetual or they can be temporary. A perpetual statute does not have any specific time limit or end date. It is in force until it is repealed, either expressly repealed or the repeal is implied in some way. Most statutes are perpetual, such as the Companies Act or the Civil Procedure Code. On the other hand, temporary statutes are in force for a specific period only, so they have a time limit. A temporary statute may be extended or renewed, either expressly or through an implication. If it is not extended or renewed, then it will lapse. For example, ordinances issued by the President of India or by the governors of the states are temporary in nature. The articles of the Constitution that enable such ordinances also specify their expiry. For example, Article 123 says that an ordinance issued by the President of India will automatically cease to operate at the expiration of 6 weeks from the reassembly of the Parliament. The Finance Act is also a temporary statute because it has to be authorized annually. On the basis of their operation, statutes may be classified into prospective or retrospective. Most statutes passed by the legislature are prospective, which means that they will be effective from a future date, on future acts or on future transactions. Statutes that are backdated, that is, statutes that cover acts or transactions that have already occurred in the past, are called retrospective statutes. In general, laws should be prospective and not retrospective. And the Constitution of India expressly prohibits conviction under retrospective laws. But Article 20 Clause 1 covers only retrospective criminal laws. Retrospective procedural laws and civil laws are not expressly banned. In fact, some amendments of tax laws, such as the Income Tax Act or the Central Excise Act, have had retrospective effect. Next, statutes can be either directive or mandatory. The best examples of directive statutes are the directive principles of state policy, which are not mandatory and they are not justiciable. That is, they cannot be enforced through the courts. Most of the other statutes are mandatory in nature, especially criminal or penal laws or tax laws. Such laws specifically prohibit certain actions or transactions or may force persons to act in a specific way under specific situations. And mandatory statutes are justiciable, that is, they can be enforced through the courts. Before we look at the classifications of statutes based on their objectives, it is very important for us to understand that a statute may have multiple objectives. For example, the Companies Act is a codifying statute. Some parts of it are also declaratory. It is also a consolidating statute because it consolidates some of the laws that preceded it. It prescribes some fines and penalties, so it also has some penal objectives. So most statutes will not neatly fit into any single category. They will come under multiple categories depending on the context. Codifying statutes codify unwritten laws in orderly and authoritative statements. For example, there were several customs and traditions that were historically being followed by various communities and groups of businessmen. If anyone broke such customs, then that person would be punished by banning him or her from trading with anyone else in that group. Now the Contract Act codified many such customs and traditions into an orderly and authoritative document. Declaratory, which are statutes that state or declare existing laws and not necessarily create new laws. For example, even before 2006, child marriage was already prohibited under different laws. However, these laws were not effectively implemented, and there was also some confusion regarding their application. So, the Prohibition of Child Marriage Act of 2006 provided clarity on the legal stance against child marriage. Remedial, curative, and validating statutes remedy or cure defects in existing laws without making substantial changes. They may also validate judge-made laws or judicial precedents by including them in the statutes. For example, the Companies Amendment Act of 2015 was introduced to simplify the procedures and remove some of the ambiguities in the previous Companies Act of 2013. The new 2015 Act provided several amendments to cure the defects and clarify the provisions of the older 2013 Act. Amending acts are similar to remedial, curative, or validating statutes because these are also making changes to existing statutes. But the crucial difference is in the scope or in the extent of the changes. While remedial statutes make small corrections or small changes, the amending statutes bring about significant changes. For example, the Information Technology Amendment Act of 2008 was an amendment to the Information Technology Act of 2000. The new act introduced changes to tackle new forms of cyber crimes, and it also included provisions for offenses like identity theft, cyber terrorism, and data protection that were not prevalent when the original IT Act was passed. Consolidating statutes consolidate multiple statutes or rules into a single statute. For example, even before 2016, people, firms, and companies were becoming bankrupt, but these situations were being handled under different laws in different ways. The Insolvency and Bankruptcy Code of 2016 brought together these fragmented laws related to insolvency and bankruptcy of corporate persons, partnership firms, and individuals into a single legislation. Enabling statutes remove restrictions or disabilities. They may make certain actions lawful. They may create new powers or permissions for individuals, organizations, or government bodies. For example, the original Constitution had right to property as a fundamental right, which meant that the state could not take over private property easily. The act or the statute to amend the Constitution to move the right to property from a fundamental right to a lesser constitutional right was an enabling statute, since it now enabled the government to take over private property more easily for public purposes. Many statutes have prohibitory, disabling, or restraining objectives. For example, the Child Labor Prohibition and Regulation Act of 1986 specifically prohibits children from being employed in several sectors or industries. Penal statutes like the Indian Penal Code specifically impose penalties, punishments, or forfeiture. Permissive statutes permit certain acts without making them mandatory. For example, the Right to Information Act grants citizens the right to access information that is under the control of public authorities. From a citizen's perspective, it is permissive because it allows citizens to seek information, but it does not make it mandatory. Like I mentioned earlier, the same statute can often be classified under different categories depending on the context. The RTI Act is a good example of this because from a citizen's perspective, the RTI Act is a permissive statute. But from the government authority's perspective, it is mostly a mandatory statute. Repealing statutes are laws that are enacted to revoke existing legislation, either in part or in whole. When a statute is repealed, it becomes invalid. But certain provisions, called the saving clause, may be included in the repealing statute or the new statute to preserve the actions that were taken under the old repealed law. A good example is the Repealing and Amending Act of 2019, which repealed 58 obsolete and irrelevant laws. Whenever a new act is passed on the same subject, it usually repeals the older act, partly or fully. If it is specifically written in the new statute that the old statute is repealed, it is called explicit repeal. If the new statute is so inconsistent with the old statute that both cannot reasonably coexist, then the older statute is automatically considered to be repealed, and this is implicit repeal. Now that we know what are statutes and the different classifications of statutes, let us now talk about the need to interpret statutes. As you are aware, the legislature makes the law, the executive implements the law, and the citizens follow the law. But what happens if the executive is unclear about the law? What if implementing the law as the executive understood it is leading to an injustice or an absurd situation? Or what if the citizens have a concern that the law as implemented is negatively affecting their fundamental rights or constitutional rights? In fact, the need for interpretation usually arises when there is a disagreement between the executive and the citizens. This is where the judiciary comes in. The courts will look at the law, all the available evidence, the situation where the law is sought to be applied, and then they will interpret the law so that it fulfills the actual intent of the legislature. Salmon's view was that looking at the mere text or the letter of the law is not sufficient. We should understand the actual intent or the spirit of the law. He said that interpretation or construction are the process through which the courts ascertain the actual meaning of the law. Lord Dennings, who was a British barrister and judge, brought out two more points. One is that when a law is made, it is impossible to predict all the possible situations and circumstances where the law may need to be applied. For example, you made laws for normal cars, and suddenly you have driverless cars, and you need to interpret how the existing laws will be applied to this new situation. The second point he made was that English language is not precise. As we have seen, the absence or the presence of a comma can completely change the meaning of a sentence. Therefore, interpretation is the process by which the courts determine the actual meaning of a statutory provision for the purpose of applying it to the situation before them. This is a quick list of situations where interpretation of statutes may be required. Ambiguity. When the language of a statute is not clear or it is open to more than one reasonable interpretation, then the courts will need to interpret the statute to determine the legislature's intent. Vagueness, that is, if a statute is vague and does not specifically address a point in issue, then interpretation is necessary to apply the statute to specific situations. If the literal meaning results in absurdity, that is, if applying the literal meaning of the statute's words would lead to an absurd or illogical outcome, then that is unlikely to be the legislature's intent. Or conflicting statutes, when two or more statutes appear to provide conflicting instructions on a particular issue, then interpretation is used to resolve such conflicts. Or gaps in the law. Sometimes statutes may not address every possible situation that may arise, and the courts will have to interpret the statutes to fill these gaps. Changes in society and technology. As society and technology evolve, situations may arise that were not foreseen by the legislature. So, the courts may need to interpret statutes to apply them to these new conditions and contexts. Case law development. When higher courts provide interpretation of certain statutes, then the lower courts are often required to interpret those statutes in line with the higher court's decisions. Application to specific cases, where courts interpret statutes to determine how they apply to the specific facts of a case before them. Use of undefined terms, that is, if a statute uses terms that it does not clearly define, then interpretation may be needed to understand the meaning of these undefined terms in the context of the statute. Drafting errors, that is, if there are errors or omissions in the statute, then interpretation is needed to ascertain what the corrected statute would likely have intended. And finally, new evidence of legislative intent. That is, if new historical documents or legislative history materials come to light that clarify the actual intent behind a statute, this might necessitate a reinterpretation of the statute's provisions. In this subject, there are two terms that we will be using quite frequently, which are interpretation and construction. Though these two terms are sometimes used interchangeably, there is a difference between them. For example, if there is a case related to an accident, and there is a question whether this particular type of accident is covered by the Motor Vehicles Act or not, then the courts will first have to interpret the Act. What does the text of the law say? Then comes the construction part, which is where the court determines how the Act will be applicable to the specific situation. So, interpretation focuses on determining the meaning of the statute, and construction focuses on giving effect to that statute. Interpretation looks at the language and the literal text, and construction takes it to the next level to consider what could be the result of the different possible interpretations of the statute. Interpretation is used in case of ambiguous language, or if there is a conflict or contradiction between the provisions of the same statute. Construction looks at the specific situation, whether it is covered by the statute or not, and how to resolve conflicts between different statutes that are applicable on the same situation, and also how to deal with new or unforeseen situations. Two important principles of interpretation that we need to understand together are beneficial and strict construction of statutes. There is a simple way to understand and remember these. Social welfare laws, labor laws, consumer protection laws, and environmental statutes, which are all intended for the benefit, welfare, or protection of the people, should be interpreted beneficially. The idea behind beneficial interpretation is to ensure that none of the intended beneficiaries of the statutes are excluded, even if the benefits are extended to those who may be on the borderline of the scope. The focus is on the intent or the purpose of the law, which is to extend benefits. If there is any doubt with the law, then the benefit of the doubt should go to the people. Tax laws, criminal or penal statutes, which can impose a burden or a punishment on the people, should be interpreted strictly. The idea here is that the scope should be strictly limited to what is clearly stated within the law. The judges should not extend the scope of the law to include situations, transactions, or subjects that are not specifically stated. Here, the focus is on the literal text of the law. If there is a doubt, then the benefit of the doubt should go to the persons who are being taxed or the persons who are being accused. So, whether a statute is being constructed beneficially or strictly, the benefit of any doubts will always go to the people. Beneficial construction of statutes is typically used in interpretation of social welfare, labor, consumer protection, and environmental legislation. The main purpose of such legislations is the welfare of the people, to extend some benefits, or for the protection of people. Here, the statutes are interpreted in a way that the purpose of the legislations are fulfilled. The benefits or the protections are extended to all the intended subjects, even if such an interpretation is increasing the scope of the law. In other words, if there is a certain degree of doubt, then the benefit of the doubt should go to the people in question. If we look at this example case between the Employee State Insurance Corporation and Highland Coffee Works, there was a question about whether the employees of the said firm were covered by the ESI Act or not. Here, the court applied the principle of beneficial construction to interpret the ESI Act in such a way that the employees would be covered by it. This was done because the ESI Act is a social welfare legislation intended to protect the interests of the workers, and the benefit of any doubts should be in favor of the workers. Strict construction of statutes is also a very simple concept. In case of penal, criminal, or taxation related statutes, they may impose a punishment, a hardship, or a burden on the people. So, such laws must be interpreted strictly so that only those situations or transactions that are specifically mentioned in the law are covered by it. In some landmark cases, the courts have ruled that criminal or penal statutes must be interpreted or constructed strictly in favor of the accused. And if there is an ambiguity in a taxation statute, it should be interpreted in favor of the taxpayer. As I have previously mentioned, if there is a doubt in a penal, criminal, or taxation related statute, then the benefit of the doubt should go to the persons being taxed or the persons being accused under those statutes. What are taxing statutes? These are nothing but statutes dealing with the levy of any kind of tax. They can also be called revenue statutes since they generate revenue for the government. These taxing statutes may deal with direct taxes like income tax or wealth tax, or indirect taxes like the GST. Without looking at the bigger picture that taxes are ultimately used for the welfare of the people, if we look at the immediate effect of a tax, it creates a burden on the person who is paying the tax. If taxes are not paid, then the taxing statutes may create a liability, a penalty, or lead to a punishment on the person who is being taxed. So, if a statute has the potential to create any kind of burden, liability, penalty, or punishment on the people, it should be interpreted strictly. Now remember, the strictness is on the statute and not on the person, which means that if a tax statute is not fully clear about whether a particular transaction is taxable or not, the benefit of that doubt should go to the person who is being taxed. Strict interpretation means that the scope of the statute is limited to whatever is specifically mentioned in that statute. No additional taxes can be inferred, implied, or extended beyond what is specifically written in that law. For example, when e-books started becoming popular, then the tax laws still had not caught up with the concept. So, if you were selling a book in both physical and digital versions, only the physical sales could be taxed, and the digital copies were exempt because the tax laws did not specifically mention anything about digital books. So, the strict interpretation of tax statutes meant that the benefit of the gap in the law went to the publisher, till the law was amended to include digital goods also into the tax net. In summary, if a taxing statute needs interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted strictly, and it is interpreted in favor of the person. The other basic principles to be followed include harmonious construction, so that the interpretation does not lead to contradictions within the statute itself or with other statutes. Also, new tax laws should be applied prospectively on transactions occurring after the enactment of the statute and not on past transactions that occurred before the law became effective. And the beneficial provisions of a statute that give any exemptions, deductions, or rebates must be interpreted to benefit the taxpayer. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Penal statutes or criminal statutes define that specific activities are illegal or criminal and prescribe some penalties, liabilities, or punishments. The interpretation of penal statutes is similar to that of taxing statutes, because even here the rule of strict interpretation is applied. The meaning of strict interpretation means that if an action is not specifically defined as being illegal or criminal under the statute, then the person who is being accused cannot be penalized. If there is any ambiguity or doubt, then the benefit of such a doubt goes to the person who is being accused. For example, smoking cigarettes or BDs in public places is illegal and people can be punished for doing so. But when e-cigarettes became popular, the statutes at that time were not clear. Is smoking e-cigarettes in public places a crime or not? For the purposes of the statutes, are e-cigarettes considered to be in the same class as regular cigarettes or not? So these were the questions where there was not much of a clarity. Since there was a doubt and the strict interpretation was applied, it meant that people could not be punished for using e-cigarettes in public places, unless and until the statutes were amended or updated. If a penal or a criminal statute needs interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted strictly, and strictly in favor of the person. While interpreting penal statutes, the concept of mens rea or guilty mind also becomes very important. That is, unless the statute explicitly says so, an act will not be a crime unless the person intentionally commits it. If an act was unintentionally committed or accidentally committed, then it will not automatically become a crime. The other principles that are applied are beneficial construction and harmonious construction. Another important aspect about penal statutes is that a person cannot be punished for an act that was not a crime when it was committed. That is, penal statutes cannot be applied retrospectively, and this is also specifically prohibited by the Constitution. For example, if a statute banning e-cigarettes was enacted from the 1st of January, then a person cannot be punished for having used e-cigarettes on the previous day, that is, the 31st of December. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Social welfare statutes are enacted to promote social justice and provide benefits to the people. For example, the Mahatma Gandhi National Rural Employment Guarantee Act, the Right to Education Act, the National Food Security Act, or the Rights of Persons with Disabilities Act. Since the objective of such statutes is to extend benefits or to ensure the welfare of the people, they should be interpreted beneficially and liberally to ensure that all the intended beneficiaries are covered. For example, if there are some benefits that are to be extended to people with disabilities. And there is a question about some disabilities that are not specifically listed in the statute. Then the court can use common sense and reasonable construction to see if the disabilities in question should be covered under the statute or not. If there is a reasonable doubt, it should ideally be interpreted in favor of the beneficiaries, because it is okay if a few unintended persons benefit from the statute. No intended beneficiary should be deprived. As is the case with all statutes, if there is a need for interpretation, the primary rules are applied first, and then for social welfare statutes, the court should use beneficial interpretation. Another point to remember here is that social welfare statutes should be interpreted dynamically to ensure that the statutes stay relevant with the changes in the society. For example, there are some laws and rules that offered some benefits to people working in offices. And after the COVID pandemic, working from home also has become normal, which means that the statutes that covered work from office should be suitably interpreted to cover employees who are working from home also. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Your university syllabus for this subject may include a topic interpretation of substantive and procedural statutes, or it may say interpretation of substantive and adjunctival statutes, or it may say interpretation of substantive and adjective statutes. If you pause the video here and read the dictionary meanings of the words adjunct and adjective, you will see that in the context of laws or statutes, they are referring to the same thing, that is procedural statutes. The terms substantive and adjective seem to have been invented by Bentham in 1843 and subsequently popularized by Holland when he used these terms in his book. But these days the preferred term is procedural, since adjective and adjunctive do not clearly indicate the purpose of these statutes. A simple example of a substantive law and an associated procedural law are the Bharatiya Nyaya Sanhita and the Bharatiya Nagarik Suraksha Sanhita. The Bharatiya Nyaya Sanhita defines various crimes and specifies the punishments. So this is a substantive law. And the Bharatiya Nagarik Suraksha Sanhita provides the procedures for giving effect to the substantive law. So this is a procedural law. As I have previously mentioned, procedural or adjunctive or adjective statutes are all referring to the same thing, that is procedural laws. Modern jurists prefer to use the term procedural law because it provides more clarity as to what is the purpose of the law. It is easier to understand the interpretation of substantive and procedural statutes if we study them together. First of all, there are substantive statutes which define legal rights, duties, obligations and liabilities. For example, the Bharatiya Nyaya Sanhita, the Indian Contracts Act and the Transfer of Property Act are all some examples of substantive statutes. Then come the procedural laws, and as the name itself indicates, they provide the procedures for implementing the substantive laws. For example, the Bharatiya Nagarik Suraksha Sanhita provides the procedures for implementing the Bharatiya Nyaya Sanhita. And if a substantive law needs some interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted either strictly or beneficially depending on the nature of the statute. Is it a penal statute, is it a welfare statute, or any other type? The rule of casus omissus is also applied here, which means that if something has been omitted or is missing from a statute, then the court should not try to fill that gap through its own interpretation. The court should interpret the law as is. Procedural law is always subservient or secondary to the substantive law, which means that the procedural law cannot supersede or override the substantive law. For example, the Bharatiya Nagarik Suraksha Sanhita cannot take away anything that the Bharatiya Nyaya Sanhita has mandated, or it cannot add something that the Bharatiya Nyaya Sanhita has prohibited. Procedural statutes are generally interpreted liberally because their purpose is to enable the implementation of the substantive law and not become a roadblock. The Supreme Court has also noted that a substantive right accrued to the litigant should not be defeated by citing a procedural defect that is capable of being cured. which means that minor procedural irregularities can be overlooked if they don't affect the substantive rights or the merits of the case. And in general, procedural laws apply prospectively because a law should not create a new procedure and expect that procedure to have been followed in the past from before the enactment of the statute. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. Directory provisions are non-mandatory clauses or instructions or guidelines within a statute. They guide or recommend certain actions, but non-compliance with these directory provisions does not automatically invalidate the actions or the proceedings that they relate to. Directory provisions often use the words may or recommend. One way of identifying whether a provision is directory or mandatory is to see what is the effect of the non-compliance. If there are no penalties or liabilities or negative repercussions due to non-compliance, then it is a directory statute. Otherwise, it is mandatory. This test was also reconfirmed by the court in a landmark 1994 case. While interpreting a directory statute, the context and the purpose of the statute must also be taken into consideration. And if the statute is directory, then an approach of substantial compliance can also be used, which means that if a person has made a reasonable effort to comply with the provisions, that can be considered sufficient, even if the compliance is not 100%. This point was also reiterated in a 1955 case that non-compliance with a directory provision should not lead to an adverse impact unless a prejudice is caused to the other party, which means that even substantial compliance is okay as long as there is no real harm that is caused by the partial compliance. And the court can also take into consideration whether strict compliance with the provisions or lenient compliance best meets the tests of reasonableness and best serves public interest. And as with any statute, any interpretation must be validated against the presumptions as to the interpretation of statutes. Mandatory provisions are those parts of a statute that are compulsory. These are not advisory or optional or suggestions. Wherever they are applicable, they have to be followed. Not following a mandatory provision may lead to an action or a transaction being deemed as illegal, void, or unenforceable, or it may lead to certain penalties. For example, if your taxable income crosses a certain threshold, you need to pay taxes and file tax returns. This is not optional, it is mandatory, and not doing so can lead to interest, fines, and other penalties. Or the Contract Act may set out some provisions that are essential for a valid contract, and not following them can lead to the contract being declared as null and void. To identify whether a provision is mandatory or directory, we can use some basic guidelines, such as if non-compliance with some provisions leads to some penalties, results in some liabilities, or has some negative effects on some rights, then it is a mandatory provision. Or if a provision has the words must, shall, or ought to, then it is an indication that it is a mandatory provision. Or by reading the provision contextually, what is its position within the statute? What is its relationship with other statutes? We can identify if a provision is mandatory or not. The process of interpretation of mandatory statutes, as usual, starts with the application of the usual primary and secondary rules. And depending on the purpose or the nature of the statute, either strict or beneficial construction is followed. And in every step of the interpretation process, we should validate the interpretation against the presumptions, such as the presumption that the legislature would not have made unconstitutional laws or intentionally created absurd laws. Codifying statutes create the code, usually where there is no specific law covering the subject, or there are several laws that overlap on the same subject. In other words, codifying statutes are comprehensive pieces of legislation that systematically arrange and present the law on a specific subject in one document. For example, there was a time when crimes were dealt with by various local customs or under different laws in different regions of the country, and the same crime could be treated in a different way in different regions. The government of that time created the Indian Penal Code, which standardized the definitions of various crimes and prescribed the punishments for such crimes, as would be applicable in a standardized manner all across British India. More recently, with the many social, economic, political and cultural changes that are happening in the society, there was a need to ensure that the criminal laws are updated and consolidated for the current requirements. So, the Bharatiya Nyaya Sanhita was enacted to replace the Indian Penal Code. Similarly, the Indian Contract Act was enacted to codify the law of contracts, especially since the concept of contracts was dealt with under the customs and traditions of different communities and regions of the country. And there was a need to standardize the rules and procedures related to contracts. Therefore, we can see that the main objectives of any codifying statute are clarity, coherence, accessibility, and certainty. Another example of a codifying statute is the Prevention of Sexual Harassment of Women in the Workplace Act. While deciding on the Vishaka versus State of Rajasthan case in 1997, the court saw that there was no single statute that dealt with this topic comprehensively. First of all, the court noted that sexual harassment is a violation of Articles 14, 15 and 21 of the Constitution, and also that India is a signatory to the UN Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. Therefore, there was a need to have one comprehensive codifying statute to deal with this important issue. And in the absence of any such specific codifying statute, the court published a set of guidelines which were popularly known as the Vishaka Guidelines in 1997. And much later, in 2013, the government enacted a comprehensive codifying law on that subject, which is the Sexual Harassment of Women at the Workplace Prevention, Prohibition and Redressal Act. As far as the interpretation is concerned, it starts with the application of the usual primary and secondary rules, and depending on what is the purpose or the nature of the codifying statute, either strict or beneficial construction is followed. And any interpretation of any statute must be validated against the presumptions as to the interpretation of statutes. Consolidating statutes are laws that combine various statutory provisions on a particular subject into one comprehensive statute, which is what the term consolidation actually means. For example, as the concept of companies was adopted and evolved in India, companies were initially governed by the Joint Stock Companies Act, followed by the Companies Act, and later the Indian Companies Act. And eventually, some other statutes were also enacted. The Companies Act of 1956 consolidated all the statutes that preceded it into one specific statute. And eventually, other laws and rules also evolved, along with the changes in the social, political and economic environment of the country. So, the Companies Act of 2013 consolidated the Companies Act of 1956 and other laws related to companies that were prevalent at that time. So, what we can see here is that whenever the law on any subject starts to become too wide and spreads across multiple statutes, then a consolidating statute is enacted to repeal the previous statutes and create a single authoritative statute. The consolidating statute will also simplify and clarify any doubts in the previous laws, and also bring in any required updates and remove inconsistencies in the previous laws. Coming to the interpretation of consolidating statutes, their primary objective is to simplify and clarify the previous laws, and this should guide the interpretation process as well. The courts will presume that unless specifically stated, the consolidating statute does not intend to bring in any significant changes as compared to the previous laws. Since consolidating statutes are practically built upon previous laws, the historical context of the previous laws should also be considered before interpreting the new statute. That is, what was the intent of the original law and whether the new law has a different intention. The rule of harmonious construction is also relied upon to ensure consistency and avoid any conflicting interpretations. And any interpretation of any statute must be validated against the presumptions as to the interpretation of statutes. As the name itself suggests, statutes conferring rights are intended to provide some rights, privileges, or benefits that can be claimed and enforced by the people who are covered by the statute. These rights can be civil rights, political, economic, social, or cultural rights. These statutes may grant new legal rights that did not exist previously, or they may clarify or expand upon existing rights, or they may detail the application of existing rights. Some example of statutes conferring rights are the Right to Information Act, which grants citizens the right to access information from public authorities, or the Hindu Succession Act, which grants daughters also the same rights as sons in terms of inheritance of property, and the Consumer Protection Act, which provides for the protection and enforcement of consumer rights. Coming to the interpretation of these statutes, the principles of liberal or beneficial interpretation are used to ensure that the primary objective of these statutes, which is to grant or to protect rights, are achieved. Strict interpretation of certain parts of the law is done to ensure that these rights are not misused. Harmonious interpretation is used to ensure that there is no conflict between the statutes conferring the rights and any other statutes. And the purposive interpretation approach is used to ensure that the rights that are granted are within the scope of what the legislature actually intended. For example, in the Society for Unaided Private Schools of Rajasthan versus Union of India decision, the court purposively interpreted the Right to Education Act to say that even private unaided schools are also required to follow the EWS reservation policies. By doing so, the court ensured that the objective of the Act to grant and protect the right to education is achieved. And finally, as with any other statute, all interpretation of statutes conferring rights must also be validated against the presumptions as to the interpretation of statutes. Someone asked, what is the difference between statutes conferring powers and enabling statutes? Aren't they the same thing? Well, they are similar, but they are not the same. I have collated the differences between statutes conferring powers and enabling statutes in this table. You can pause the video and read through this table. But the key difference between these two types of statutes is in their typical scope. Statutes conferring powers empower or enable existing entities. For example, the Bharatiya Nyaya Sanhita enables existing police departments, whereas enabling statutes typically facilitate the creation of a new entity and then enable or empower them. For example, the SEBI Act led to the creation and enabling of SEBI. We can say that statutes conferring power tend to be more specific and limited in scope as compared to enabling statutes. Statutes conferring powers are enacted to grant or to delegate specific powers to specific individuals or bodies. These are powers to perform specific functions or to take some decisions on a specific subject. For example, the Motor Vehicles Act confers powers on the state transport departments to regulate road transport within the respective states. It includes authority over vehicle registrations, issuing driving licenses, and enforcing traffic rules. Another example is the Bharatiya Nyaya Sanhita, which grants specific powers to police officers regarding arrests, searches, and investigations. The powers that are granted or conferred by these statutes can range from administrative or regulatory functions or enforcement and decision-making authority. If we look at statutes conferring powers in general, they enable the executive to perform their functions by giving them the requisite powers. Coming to the interpretation, it starts with the application of the literal, golden, and mischief rules. Strict interpretation is followed to ensure that the powers granted are within what was intended by the legislature. The purpose and the legal context of the statute are also considered to interpret the scope of the power. Any powers must be explicitly conferred, and if there is any ambiguity or lack of clarity, then it is interpreted against the grant of that power. If any powers are to be implied, then they must be absolutely essential for performing the intended functions. For example, if the traffic police are given the function to regulate traffic, it can also be reasonably implied that they have the power to declare certain roads as one way or create rules to restrict certain vehicles on certain roads at certain time. The court will also consider any limitations that have been laid down on the exercise of such power, either within the same statute or elsewhere. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. I have previously explained that though there are similarities between statutes conferring powers and enabling statutes, they are not the same. You will notice that the scope of enabling statutes is more than the scope of statutes conferring powers. Enabling statutes in general create specific entities or organizations and also empower them to create laws, rules, and regulations within specific areas. For example, the Securities and Exchange Board of India Act or the SEBI Act enabled the creation of SEBI and also conferred the powers on SEBI to regulate the domain of financial securities and stock exchanges in India. Similarly, the University Grants Commission Act enabled the creation of the UGC and also conferred powers on the UGC to regulate universities across India. While interpreting enabling statutes, as usual, the courts will first apply the primary rules such as the literal, golden and mischief rules. Strict interpretation is used to ensure that the authorities or the entities that are created act within the limits set by the enabling statutes. Purpose-oriented approach is used to ensure that the purposes of the enabling statute are addressed. Harmonious construction to ensure that there is no conflict within the same or with other statutes. The organizations that are created and the powers granted to them should all be in compliance with the Constitution. And the rules created under the enabling statute should be reasonable and comply with the procedures prescribed by the enabling statute. And any interpretation of any statute must be validated against the presumptions as to interpretation of statutes. With that, we will end this video. If you have any questions or feedback, post a comment below, and I will see you soon in the next video. Take care and Jai Hind.